Sergeant Barrett, you're familiar with what I mean when I say the walk the dog letter, right?
Yes.
It's docket 214, but every law nerd on the internet calls it the walk the dog letter.
Kouri Richins, the Utah mom accused of poisoning her husband with a lethal fentanyl cocktail, is back in court as her legal team fights to keep some key evidence out of her upcoming murder trial. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. 34-year-old Utah mom of three, Kouri Richins, appeared in a Summit County courtroom Thursday for a hearing addressing multiple issues. You see, her defense attorneys want to suppress several key pieces of arguably damning evidence against her, meaning they don't want them to be allowed into her upcoming trial. They don't want them to be heard by a jury. Now, at the center of this debate are statements that Richins allegedly made to police, data from her phone and Apple accounts, and the infamous walk the dog letter that was found in her jail cell, which we'll talk about in a moment. But in case you need a little bit of a refresher on what is certainly a wild case, so Kouri Richins is accused of giving her husband Eric a lethal dose of fentanyl in a Moscow Mule on March 4th, 2022. Prosecutors allege that she tried to poison him before, though, spiking a sandwich with drugs on Valentine's Day. Now, what would be the alleged motive for a wife to kill her husband? Money. Money. Of course, isn't that one of the main motives we see in so many of these cases? Well, Eric was reportedly worth about $5 million. Kouri was allegedly drowning in more than $3 million worth of debt in her house flipping business, and prosecutors say she had secretly taken out life insurance policies totaling nearly $2 million on Eric just months before his death. And she allegedly forged his signature to take out a $250,000 line of credit behind his back. And here is where things get really bizarre, because a year after Eric's death, Kouri published a children's book called Are You With Me? About coping with the loss of a loved one. She even went on local television to promote it, talking about helping her sons deal with their grief. And remember, she is now accused of being responsible for their grief. So the investigation uncovered some seriously, arguably incriminating evidence. Forensic analysis of burner phones used by Kouri revealed disturbing searches like women Utah prison, how to permanently delete information from an iPhone remotely, what is a lethal dose of fentanyl. She also allegedly Googled how long does life insurance take to pay, and if someone is poisoned, what does it go down on the death certificate as? Now, Richins is facing a slew of charges. She's actually facing 9 charges. Our understanding is 5 of which will be at this upcoming trial. So aggravated murder, attempted murder, forgery, and insurance fraud, and other mortgage fraud and forgery charges. Those are going to be severed, and they're going to be addressed at a different trial on a different day. Now, she has pleaded not guilty across the board. She's been denied bail. If she's convicted, she could spend the rest of her life behind bars. So now it's been nearly 3 years since Eric's death, 2 years since Richins' arrest, and Richins is finally going to trial. But before it gets underway, in April, last-minute motions are being filed. And these are very, very important in terms of what this trial will look like, what evidence can be presented, maybe who will get an advantage going into this trial. So last week, Richins was back in front of a Utah judge. And this is as her attorneys have been pushing for evidence to be thrown out. Again, suppressed. So I want to dive into it with you. So first, the defense claimed that police had questioned Richins for 5 hours without reading her Miranda rights, and this was back in April of 2022, and this is a big no-no. And then they say in April of 2023, nearly a year after Eric's death, a new detective joined the case to provide some fresh perspective.
At that time, with the limited information I had, the most important fact that I felt we knew was that Eric died of fentanyl overdose. Mm-hmm. So the biggest question to me was how the fentanyl got into his system. And in my opinion, there were basically 3 different ways that Eric could have died of a fentanyl overdose. It could have been an accidental overdose, it could have been a suicide, or it could have been a homicide. In order to be thorough, I was trying to investigate all 3 of those possibilities.
So 1 year after he died, you still had no idea whether it was a suicide, homicide, or an accident?
That's correct.
So we have Detective Jeff O'Driscoll, who testified during the hearing that he visited Richins to get to know more about her and the case.
She seemed very cheery, very open, happy to be talking with us, happy to have the opportunity to talk to investigators. She was outgoing.
By the way, as you know, we always talk about some scary stuff here on Sidebar. We always try to partner up with companies that can maybe add some protection to your life. I mean, did you know that your personal data is being harvested and sold online by data brokers? Yeah, anyone can buy your personal details. And when that happens, you're at risk for a whole host of things. Identity theft, becoming a target of phishing scams, potentially stalking. But that is why I'm so happy to tell you about our sponsor, Delete Me. So Delete Me helps you keep your personal information private. They found dozens of data brokers with my personal information out there, posted on so many listings, but Delete Me helped to remove them. And they will keep monitoring the sites for you so your information doesn't find its way back on there after the first removal. And honestly, using Delete Me, it has given me peace of mind about my family too, because if someone buys your data via a data broker, they can also see information about your relatives too. So right now you can get 20% off of Delete Me and protect your personal data when you go to joindeleteme.com/sidebar. Use promo code sidebar at checkout. But the defense says Detective O'Driscoll violated Richins' constitutional rights by conducting a recorded interview despite knowing she had legal representation.
You intended to go in there and ask Kouri questions directly about what happened with her husband's death, didn't you?
After she invited us in and consented to having us interview her, yes.
When she invited you in, did you Mirandize her?
No.
Right. Did you know she had a lawyer?
No, I did not.
You did not? All right, let's look at the transcript for just a moment.
So my attorney has been pushing to, obviously we just wanted her off the case because we're not getting anything done, anything accomplished.
And who's she talking about wanting off the case?
I think she was referring to Detective Woody.
So minutes into your meeting with her, she advised you she had an attorney.
Yes.
And you knew that you were going to elicit information from her that could be used against her, did you not?
I didn't know what information she would provide. I just wanted to know the facts surrounding the night of his death.
If she had said, hey, I killed my husband, would you have used that against her?
Likely.
There was also another contested search that happened when Richins was arrested back in 2023. So her attorneys say that police improperly read and seized a notebook that they say contained privileged communications with her therapist before getting the proper authorization. Now, the judge decided to table that particular issue for now until he and the attorneys can have a private meeting about it. But the defense is also trying to do something else. They're trying to block prosecutors from using data from Richins' phones and Apple accounts, arguing that the search warrants were overly broad. Detective Eric Maynard testified about a traffic stop before Richins was arrested. Now, actually, it was when they served a search warrant on her home. She reportedly left the home. That's when the stop happened. And when it did, this is where they apparently seized her phone. He claims that Richins voluntarily handed over her phone and password, but admitted he never explicitly informed her of her rights or asked if she wanted an attorney present. And going back to what I mentioned before, Richins' defense team wants to suppress the explosive letter that was found in her jail cell, claiming it contains privileged attorney-client communications. The prosecutor said law nerds on the internet, hopefully not referring to us, calls it the walk the dog letter. It's called that, by the way, because the words walk the dog are apparently written across the top of it. But prosecutors have accused Richins of using that letter to coach family members on how to testify. Now, jail staff testified about searching Richins' cell multiple times after she had some sort of medical incident, making sure no items had been left behind by emergency personnel. But then deputies searched Richins' cell again that same day after it was reported she had held up a piece of paper during a video call. So officials wanted to find it, see what it said. Then the next day, there was a search of the entire unit, and Richins was being moved to a new cell, so everything was being looked through.
So initially, she was taken out of the jail for a medical situation.
Yep.
And there was a search on September 13th, and all you were looking for was if anything was left behind by the EMTs, is that correct?
Initially, yes.
Okay. And then when was it you became aware of a video call that led you to want to search the cell further?
So as while she was away from the jail, that was brought to my attention that there was possibly something held up in a video chat. So we searched the cell looking for a piece of paper with cursive handwriting on it.
Now, the defense claims that this walk the dog letter was in an envelope marked attorney privilege, but jail officers said they found it tucked inside of an LSAT prep book. The LSAT, by the way, is the exam that you need to take to get into law school. But either way, Richins' team argues that it should be off limits due to attorney-client privilege, that this shouldn't come into evidence, and the defense went round and round and round about whether the deputies actually read the letter or whether they just looked at it.
So the documents were in the envelope that you were going through. Are you aware if some of those documents have since been found to be privileged documents?
Are you asking me, were they in that envelope that I was
Well, no, what
searching?
I'm asking you if the documents that you were reading that were in the envelope contained privileged documents.
Yes, I wasn't reading them, though.
Well, you were going through, you said hundreds of documents.
Yeah.
So you would have had to have at least read some to get an idea of what they were, correct?
Inspecting, looking at, the heading on it, like, court paperwork to me is pretty obvious, like headings.
Well, there were a lot of handwritten documents in that envelope, correct?
Correct.
And you determined not to seize any of those documents, correct? Mm-hmm. And you, as you were reading those documents, you determined that some of them were privileged and you should stop reading them, correct?
I didn't read them.
Then how did you know what they were?
Just glancing at them.
Okay.
Now, when another deputy takes the stand, it is interesting to see how far into the weeds the judge is going to allow the defense attorney to go before pulling her back.
So when you saw these pages that were in a handwriting, you read all of them, right?
I read most of the document on my way out, because once I verified that there was something in there of concern, then I was taking them out of this section to take to my supervisor.
So the very beginning of that, in front of you, the first couple of lines, and you can just read it to yourself right now,
Okay.
is about a conversation between Ms. Richins and her attorney, correct?
No. It's saying she's referring to this guy as the third person.
Right, she's talking about something that her attorney told her, correct?
Correct.
All right, so as you started to read this, you immediately saw that she was talking about something between her and her attorney, correct?
Correct.
But you continued to go on and read it?
Correct. So I scanned the document, and then fairly quick, she talks about basically what she's telling her brother to say.
Well, I understand that's what your interpretation of the document is, but let me back up a little bit. Mm-hmm. So when you come across documents that are privileged, do you typically go on and continue to read them?
They weren't marked as privileged.
When you come across documents about an individual's case that they've written?
We scan those documents just to look for safety security threats.
You scan them or you read them?
Scan them. Or you read them until you determine that it's a legal document when it's a handwritten letter that's not in a legal folder or anything like that.
Now, you refer to that as a letter, but is that a letter addressed to anybody? Does it say Dear somebody at the top?
No, not at the top. At the back of it, it clearly is addressed to her mom.
Well, wait a minute. Let's clarify here. Addressing a letter would, there's no,
Hold on.
oh, sorry.
Go ahead, Mr. Bloodworth.
Like all the other documents in this case, it says what it says. We don't need a quiz on what it says.
Are there questions about why Sergeant Thomas did or didn't do whatever he didn't do next that you need to ask?
There is, and it's laying foundation for argument that will be made in the briefs.
If you need to ask questions about what he did or didn't do, that's fine.
Well, I think it's important to clarify, for purposes of argument and privilege, whether or not this document was obviously a letter.
Well, but you can, candidly, I don't care whether he thinks it was obviously a letter. I can address and I have to, under the law, make an objective determination of that. If you want to ask him why he did whatever he did or didn't do next, that's fine.
Okay. All right. Well, can I get an answer to the first question? Is there a salutation on the letter to somebody?
No.
All right. But you continued to read it
Correct.
anyway. And it's not signed on the bottom by Ms. Richins. It's not Love Kouri on the bottom, correct?
I would have to.
I'll go ahead and take a
Ms.
quick
Lewis,
look.
if you just ask the next question, I'm going to move you along just a little bit here.
Was there an envelope with that to mail it?
No.
Were there any letters in her cell that were ready to be mailed out that you found that day?
I don't recall any. This is the only letter I remember. This was the only letter of significance that I felt was a violation of rules and a safety security threat.
All right, and it was attached to 3 other pages that were just notes, correct?
Yeah, it was just like a checklist it appeared to be a checklist. I couldn't really tell you everything that was on it on the last 3 pages.
Okay, but it wasn't you didn't think it was part of the first 6 pages?
Yeah, I thought it was part of the actual document, yes.
All right, are you aware that the next page, page 7, was found to be privileged by the taint attorney in this case?
No.
You're not aware of that?
The court also had the chance to see security video from inside the jail unit where Richins' items were searched, and you can see this deputy going through things on the video as the prosecutor questioned him.
Is that the LSAT book in your left hand where you found the letter?
Yeah, it looks like it.
Is this you using your cell phone to take a photograph of that?
Correct.
And is that the photograph that, if you know the number, but is found at 86 in the court's binder? We can show you that photograph. Do we have it real quick? Your Honor, can I borrow the court's binder to show? Sergeant Thomas, is the court showing you Exhibit 86?
Yes.
Is that the photograph of the LSAT book where you found the walk the dog letter?
Correct.
And is that the photograph you took that was depicted in the video we just watched?
Correct.
You please hand that back to the court.
Ms. Nestor, Ms. Lewis, you have 86, right?
Yes, Your Honor.
Very good. Thank you, sir.
To recap, you found the walk the dog letter in the LSAT book, correct?
Correct.
And you never searched a folder, a manila folder during that entire search we've just discussed?
Not that I recall.
You never
I don't
searched,
remember it at all.
and you never searched a folder with Ms. Lazzaro's name on it?
Negative.
And you conducted your search at the head of the bed?
Correct.
Head of the bed is about 6.5 feet from the foot of the bed where Sergeant Barrett was standing?
Roughly, yes.
No further questions. Thank you, Your Honor.
The defense circled back to the legality of one of the search warrants that were served on Richins for her phone, saying again it was overly broad, but the judge is starting to get worried about how long this hearing is going on for. So the state says it had planned to call an investigator to talk about the warrant and how it's very similar to other warrants approved by Utah courts. There's even a precedent there. But after discussing it with the judge, the attorneys came to an agreement.
Given the fact that this court has approved so many similar warrants and just probably knows that.
Well, the other issue that I think there's a scope of the inquiry issue that I have here is that the warrant was issued. It says what it says. Is there a legal route for collateral attack on its scope at this point?
So,
I mean, once it's issued, isn't the only routes of attack either that it was secured through fraud, that's a Frank's hearing, or that its execution was unreasonable? But as long as the information seized or secured is within the scope described by the warrant, is there a legal basis for the warrant was overbroad when issued kind of attack?
Your Honor, the state doesn't believe so. And to be clear, that the defense in their motion has not challenged the veracity of the probable cause under Franks.
Understood.
The defense has not challenged the execution of the warrant. They are indeed challenging the four corners of the warrant as issued.
Help me understand, Mr. Ramos, what's your hook?
It's a lack of particularity described in what to search for within it.
And let's assume you're absolutely right about that, and that the judge that issued it missed it, wasn't sufficiently attentive. At this point, though, where we have, I believe, good faith reliance on an overbroad warrant, isn't it black letter law that that's not a violation of the Fourth Amendment?
Well, no, I don't believe so. If it was issued and it lacked particularity, Your Honor has the discretion to go back and either suppress it entirely.
Do I have that authority?
I believe you do, Judge, based on case law.
Okay. And you'll be able to cite me to that?
The way I've read it, yes, Judge.
Okay.
Now,
All right.
that's assuming Your Honor believes it does in fact lack particularity.
Okay.
If it doesn't,
Well, I need to give you a fair opportunity to lay that foundation, though, and make your arguments.
now to be fair, coming into this motion or to this hearing, we were going to just submit on the four corners and just brief it. So I had no plans on calling anybody. However, I understand the state's position of wanting to call Mr. Kotridemus.
Candidly, I really don't care what Mr. Kostridemus thinks is typical. I mean, I'll wager with him about how many of these I've seen versus how many he's seen. And so I think I can make that call.
And the state's comfortable with that, Your Honor, because candidly, the court has signed warrants with identical language.
Yeah, probably so.
It is our stock language that we use in every phone dump warrant.
Right. But I need to give Mr. Ramos an opportunity to make his arguments. And so,
If,
yeah.
well, that, Your Honor, I believe that opportunity will come in paper.
Yeah.
I'm happy to limit this based on the court's experience with such warrants to the four corners, not call Mr. Kotridemus and move on.
Is there any evidence you feel like the defense needs to put on to provide the record from which you can make your arguments regarding this warrant is infirm because of a lack of particularity?
Judge, I believe that I'm limited to the four corners.
Okay,
I don't believe I can present any evidence, even if I wanted to.
understood.
Should he want to do it, and I'd certainly love a chance to cross-examine
No, I
somebody.
don't. Candidly, I don't think Mr. Kotridemus's testimony on that issue is going to be particularly persuasive.
And as I mentioned, this case is speeding towards trial with jury selection scheduled for the last week of April. But the court is going to be back in session before then to tackle any more pretrial issues.
We need to talk about deadlines. I am happy to let all of you talk amongst yourselves, agree to some briefing deadlines, and tell me what they are when we convene on February 3. Is that agreeable?
Yes, Your Honor.
Yes, Your Honor.
So yeah, pretty much everything we just went through is going to have to be decided at a later date, but we will keep a very close eye on this and how it develops, because what is decided before trial, as I mentioned, could have a significant advantage for either the prosecution or the defense before they actually make their arguments, present their evidence in front of this jury. So again, the trial starts April 28th, and you're going to be able to stream it all live on Law&Crime's YouTube channel. But that does it for us right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. I'm Jesse Weber. I'll speak to you next time.